if I don't do nothing else, I'm gonna talk that law. Let's talk about it. Let me see what's going on. For those who don't know me, I'm a Texas trial attorney going on my 5th year. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court? Now, I was minding my business. I was drinking my water. And I heard it was an update. An update. At the trial today, the YSL trial. Apparently, the judge want to know. The judge say, who is the mole? The judge say, who the mole, goddammit? Oh my goodness. And apparently he ain't gonna stop until he find that mole. The judge say everybody going to jail. Everybody going to jail till I find out who betrayed me, who stabbed me in the back. Judge say I'm locking all y'all up. Oh my goodness. The judge say I'm locking all y'all up. And what's her name? Bumpass. He gonna lock her ass up first. Woody, did you throw your attorney under the bus, or did that something that y'all agreed to behind the scenes? Woody, why did you do that woman like that? She wasn't even your real lawyer. She was a substitute. And you get on national TV and you say she fired. How the hell you fire her, Woody? Talking about she fired, ain't paid her $1. He ain't paid that woman $1. She was actually subbing for his original lawyer. And they say, what they say, no good deed goes unpunished. She done took her ass. We're gonna find her. Hold on, we're finna find her. We finna find Miss Bumpass. Bumpass. They say Miss Bumpass got a bump on her. Y'all are wild. Y'all are sick. Let's see if we can find a picture of Miss Bumpass. Where we at? Hold on, I got so many screens open. But I bet you I'm finna close some of them out right now. Who is this? Okay, we got that one, and then okay, bet. Okay, let's see if we can find what she looked like. I seen her in court today, but let's see if she got a. Here she go. Now, what's his name? Oh, it didn't open. Now, why you do this woman like that? Why you do her like that, Woody? She a young lawyer trying to make it in the game, and you done threw her under the bus. Did you tell somebody she's the mole? Is she the mole? Y'all think that Kate, what is it? How you say her name? Kayla is the mole? Kayla, I know you didn't do this, Kayla. I know you didn't do this, because if you did this, Kayla, and Brian Steele, he get tired of eating that jail food. He get tired of eating that jail food. He might tell who told him. He may say, damn it, you know what, Judge? It was Kayla. Kayla told me y'all was in there having a secret meeting in the back room. And if he found out it was Kayla, he gonna send her ass to jail. Straight to jail. She not gonna pass go. She not gonna collect $200. She going straight to jail. And that's one thing about judges. They can do stuff, and there's really nothing you can do about it right away. You have to wait to a higher court, sit them down. And sometimes that takes forever. It takes a while for a higher court, or appeals court, to come in and say, Judge, you was wrong. But even if they say he was wrong, she's still gonna have to be in jail for 20 days. Who want to sit in jail for 20 days? Because you want to ever be able to get those 20 days back. But the judge, he said, Kayla, I know your client want to fire you, but guess what? I'm not gonna let you go. Not just yet. The judge even started making up rules. The judge said it takes 10 days for a lawyer to withdraw from a client. Now, I don't practice in the state of Georgia. I practice in the state of Texas, the great state of Texas. But I ain't never heard of a rule where it takes 10 days for a lawyer and a client to separate. And matter of fact, one of the other lawyers corrected him, and they said, Judge, you don't know what the hell you talking about again. You don't know the law. They say the client can waive that 10 days if they choose to. Now let's see what we got. The judge signed an order, a show cause order. And let's read and see what if we can go through it and figure out what the show cause order say. What does the show cause? Not a show cause. What is a show cause? Let's read it. Let me see if I can make it a little bit bigger. I'm on somebody Twitter page. They got the order. Oh, y'all ain't gonna let me make it bigger? All right, how about I do this? What if I take myself down? Well, if y'all can't read it, I'll read it to you. I'll read it to you. All right, here we go. It says the court having been presented with an issue of contempt for determination, all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, 2024, to include the witness, Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpass, and all representatives of the state and court security personnel that were in attendance are hereby ordered to show cause before the Honorable Glanville on 25th day of June, 2024 at 9 o'clock in the morning. And he want to know why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to the members of the defense counsel. And he goes on to say, and guess what happens if you don't show up? It is further ordered that The failure of any individual who were present for the June 10th, 2024 ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them before the bar of this court. So what y'all think? What y'all think? Do y'all think somebody finna go to jail? Do y'all think the mole is finna be discovered? The mole is finna be discovered. I want to go and see if we can play some of that video. Let me see if I can find. Let me see. If I was Kayla, I would definitely try to look into getting my own self a lawyer because it's not gonna go good for her. Like the state, they kind of covered. I mean, their boss is Fannie Willis. The judge ain't gonna really press them. Does he know who their boss is? The deputies, same thing. They covered by the sheriff's department. They work with him in his office. So he's gonna automatically be inclined to trust his deputies. But Kayla, an outsider, he gonna automatically assume that it was her that did the it was her that did the snitching. Let me see. Kayla. And what I might do tomorrow, since I already have the day off tomorrow, I might jump on and cover some of it while Woody's testifying so we can cover some of his lies together. So instead of doing a recap at the end of the day, we're going to be recapping it at the beginning of the day. God damn it. Let's see. I'm gonna go to the video where we can say where let's see where Woody. All right, here we go. I'm gonna share my screen when he's actually firing her. I don't know what caused him to fire her. Maybe he was told that she snitched on him. She told people that he confessed to murder, and now the world knows that he admitted to allegedly killing Donovan Thomas, aka Nut. So he's probably mad at his lawyer. He think his lawyer snitched on him and told Young Thug's lawyer.
Okay, before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpass, would like to be released. Is that correct, madam? Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
Hell yeah.
She fired.
She's fired?
She fired.
Okay. So do you wish to represent yourself?
Wait a minute, did the judge act like he didn't hear?
In terms of any issues you may have in this particular...
Go back.
So do you wish to represent yourself in these particular... In terms of...
Oh, I didn't go back far. I want to hear him say she fired.
Is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself?
Just said she fired.
In terms of any issues you may have in this particular.
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right
I don't
now.
want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
He said he don't want to. He said,
What I need a lawyer for? It's, what
No, it's just the court is just.
okay, so obviously he don't know what's going on. He's in the middle of he's sitting in the middle of court testifying in a RICO trial where his life is on the line because they can charge him next, and he's asking the judge what I need a lawyer for. You got to be kidding me. What did you mean? What you need a lawyer for? Did you not see what happened yesterday? You went in the room and you confessed allegedly the murder, and it got out to the public. We know about it. And you're really asking the judge what you need a lawyer for? And you expect this judge to tell you the truth? Look at him. Look at the judge. He ain't no damn good.
Asking you.
lawyer. What I need a lawyer for? It's,
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpass, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually has to be in writing, and he has 10 days to object. Say again?
I was never his counsel. I didn't know he was his counsel, and I was stepping in as a courtesy for judicial officials. But if the court's desire for me to file a motion to withdraw.
She in trouble now.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have
That's not true.
because he gets that particular period of time
No, he don't.
to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on.
All right. Shut up, Woody. God
You get
damn
that right as a party.
I
Okay.
think you're right.
You do. Yes. You get that right to hire a new lawyer. You get the right to do a couple things. One,
Y'all caught that? He said, "Oh, I get rights now. I didn't get rights when y'all had me healed up in your chambers the other day."
you get that right as a party.
I
Okay.
think you're right.
You do. Yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you will release her.
Okay.
Okay. Two, you get to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay, those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw. But you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have noticed or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point.
He not gonna do
I'm
it.
sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance.
Yeah, right.
So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days. But until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
So as y'all can see, she wants to get off the case because apparently she's now been accused of being the mole. She's been accused of being the mole. So now she's saying, hey, Judge, I didn't sign up for this. I was supposed to come here for one day only because the regular lawyer went out of town. He got tickets, I say, to Disney World. I don't know where the hell he at. I'm assuming he in Florida. And he asked her to fill in for him for one day. Now the judge is saying, hey, since you're here, you're stuck. Not only are you stuck, now I'm accusing you. He put the other people in the order just for show, but he's really accusing her of being the mole. He's accusing her of being inside his chambers, and then after everything was over with, she went out and she secretly told Brian Steele, Young Thug's attorney, and all of them that, hey, I was in the judge's chambers and we were secretly meeting with Dalshaw. What? So, as y'all can see, she got herself, she between a rock and a hard place. And I don't know what she's going to be able to do at this point because the judge, he eventually, I'm going to find the end of that clip. He eventually released her. He let her go on her way, but he said, you got to come back. You got to come back because I'm going to have a hearing. I'm going to put y'all under oath and I'm going to sit y'all in the hot seat and I'm going to get to the bottom of, who told the secret information from my office. Apparently, Woody fired her the day of the ex parte meeting, and Judge pretty much forced her on record to still. Oh, okay. So you're giving me some good info. So apparently, Woody must have found out that exact same day that his conversations got leaked out, and now he's what they call big mad. Golly. So why the hell she showed up today? I'll get over, like you said, the judge made her come. Now, I don't know if that's going to be appropriate because if a lawyer and a client not getting along, then you can't keep them together because he's going to feel like she's not doing her best. And hell, she may not do her best because she might be, halfway mad at Woody. Hey, good evening. Yeah, I had court myself, but I caught bits and pieces of it. And Woody did. I figured he was going to show up because I personally thought that he didn't have the resources to flee. He might have a shoebox full of money like Fannie Willis hiding under the mattress. I don't know what that man got. I don't know what that man got in his pocket, but I just knew he was going back to court. Because even if he didn't, he probably can run, for a day or two at most before they find him and drag him back to court. Wasn't it one witness that didn't want to come to court in this trial and they end up arresting her and they held her in jail? And then finally she promised the judge she was going to come back and he put an ankle monitor on her. And then he told her, he was like, I'm not going to tell nobody, where you're going. And then he slipped up and said that I'm not going to tell nobody you're going to Tennessee. Like, what the hell? You finna get this woman head knocked off. Right after that clip, when Woody he's back to the courtroom, he catches her talking to the state, and you can't see his face, but based on her reaction, it had to be something. Hold on, I gotta find it now. Hold on. Wait. She better find her something safe to do because apparently Woody about their life. But I doubt he do nothing crazy. The block is way too high right now. Let me see. I'm gonna find that clip. And that's the thing. She too comfortable with the state. Like, why are you buddy with the state? Like, for what purpose? I think I found that clip. Okay, I'm gonna pull that other clip up. I think I found it. Let me see. You said, all right, let me see. I'm gonna share my screen. I mean, she stuck like Chuck. She done stepped in it now. She should have known better though. Ain't no way in hell I would have went up in there. Because especially if you know how the judge been doing this trial, like why would you put yourself in that situation? Let's see.
I'm sorry that you put yourself in this particular
He said the same words I just said.
situation with you and Mr. Melnick and whatever, but you know, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
He already said he didn't want her.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Also, can we approach? Can I approach Your Honor with the state?
No. What does he want to tell me?
I don't want to say it in open court.
Nah, we're not doing that backroom business no more. You're gonna have to say it now. Yeah, you in court now. Yeah, I want to hear it loud and proud. Hell, she just got in trouble for going to the back room. Why the hell would she want to go back there again? Right here is the judge covering his for the ex parte meeting. He has to put the blame on someone, and now on record, he specifically tell her that she's still his lawyer. Oh yeah. But the judge, being a judge, he should know better. You should know.
All right, State, Ms. Bumpass, come on up.
Oh look, he calling her up. Look at his body language. His arms are crossed. He is big mad. I'm talking about Woody now. Let me see if I can fast forward.
I do think we have state objection.
Oh, they objecting again. They objecting. They saying, y'all, hey, what's going on?
State objection for the record. I do think we have right to present, and I think there's case law to that effect. I want to check on the grounds that we are now being excluded from a conversation about material witness in prosecution, state versus demon defender, and material witness, conversation about material witness, and a conversation between the court and that counsel for that witness and the state, which are now conducting a meeting with the court without the ability for me as the attorney for the defense in our case to be present and knowledgeable.
Oh, here we go.
That that ex parte communication creates an appearance. I say this with tremendous reservation, and I almost want to apologize for saying it.
No.
I think it creates an appearance of impropriety and bias on the part of this court. I don't mean to suggest Your Honor is doing that, but it creates the appearance of it. So
No, that judge doing it. Don't apologize. He doing this shit on purpose. Tell him.
Okay. Your Honor, I'd like to just add, I'll adopt everything that's now said, but I'd like to just add also under Article 1, Section Paragraph 12 of the Constitution, it also denies Mr. Williams his right to a critical stage of the proceeding.
And sorry, Your Honor, if I could just add to that for the record. I'm going to cite to the Uniform Superior Court Rule 4.1, which prohibits this type of communication.
Tell it.
Cite to the Georgia Code of Judicial Conduct, Rule 3.4,
Put that law.
prohibits this type of communication.
Put that law on his ass.
I'll cite to the court several cases which I believe support that. First is Monday versus Magnolia Advanced Materials, which is 815 Southeast 2nd 70.
Look at Miss Love Madden. Look at her. Miss Love Madden, the B.
Georgia Supreme Court in 2018. I'm going to cite to the court Lynn versus State, which is 139 Georgia Act.
I will point this out, Miss. Atlanta. They eating good in Atlanta, and Miss Bumpass. Back in the day, they call them cornbread fed. But I don't know if that outfit appropriate for court. That's just a observation I made.
1976 case.
Somebody said she looked like a backup dancer for Aaliyah. I was like, what?
Trial judge should not attempt to intimidate witnesses to testify on behalf of the state either in or out of the presence of the jury. And it also creates a presumption that the court should have to recuse itself. In that case is Hargis versus State. And that's 319 Georgia Act 432. That is the Georgia Court of Appeals case from 2012. I think you're wrong.
Your Honor, I assume Harvey will be back for all these.
Okay.
items.
No lies told. Oh, then the judge making him go back. And then the judge. See, my thing is, y'all did all this talking in the office. Why couldn't y'all do this in the open yesterday like y'all did today? And I don't think, I went back and watched the video. I don't think it was Miss Hilton. Hilton didn't tell a damn thing. It was somebody else. It wasn't her.
Your Honor, I just wanted to be given an opportunity to be able to respond to that on the record and to point out that the distinction between the assertions by counsel for the defendants and what is going on here, and the assertion being made that a trial judge should not intimidate or coerce a witness. Actually, can we?
Yeah, hold on a second. Mr. Can I get you to step outside for just a second? Let me finish this argument, please, sir.
Now he trying to put Kenneth Copeland outside, but Kenneth Copeland was in the goddamn room with y'all yesterday. Why you putting him out the courtroom now? I don't even know what this about. Don't try to appear fair. And Miss Love, listen to her talk. She gonna say the same thing about 5 times. Easy.
Mr. Copeland?
Wait, you want me to go out?
Yeah, just step outside in the vestibule if you wouldn't mind, sir, please. Thank you. All right, Mr. Copeland's left us.
That's a joke.
Your Honor, what I believe that Ms. Bumpass wants to address with the court is strictly and solely the civil matter that involves the motion of the state to compel her client, Mr. Copeland, to testify, the offer from the state of immunity should Mr. Copeland testify, and the motion of the state to the court to sanction Mr. Copeland if he fails to comply with an order of the court pursuant to 24-5-507. That matter is a separate matter from the trial that is going on now. It is akin to the state moving the court for a material witness warrant for a person who refuses to obey a properly served subpoena. It is not something to which either defendant is a party. And for that reason, it is our position that counsel for the defendants are simply wrong in this instance. And that if Ms. Bumpass chooses to address the court with the state regarding a matter to which the state as a moving party and her client as the person for which the state made that motion are involved only, then the parties to that matter are the state and Mr. Copeland. And so for that reason, I believe that Ms. Bumpass is entitled to address the court.
Why the hell is she speaking for Ms. Bumpass? Ms. Bumpass a whole damn lawyer up there. See, it just seemed like her and Bumpass too buddy for me, because I don't need a prosecutor to speak for me and my client. You put what you want to put on the record with this leprechaun ass, green ass jacket on, and let me handle mine.
With the other party in that matter, which is the civil contempt order entered by the court on the motion of the state at the time that the state moved the court to compel the testimony itself.
All right. I don't know what she's going to say, so
Exactly.
that may make it not subject to ex parte or not. But what does he want to tell me, madam? Can you tell me the subject matter?
Yeah, about when he said he fired. And
Well, no, that we have to have a hearing on that issue. We have to have a hearing on that.
okay.
We'll have to have a hearing on that issue. That's not an ex parte matter, okay?
Oh, now he's saying it's not an ex parte matter. None of this should have been ex parte. Now all of a sudden, see, now he's not being consistent. Because if y'all had the same meeting yesterday and now she want to talk about it again, but now you're saying, oh, it's not an ex parte matter. Why the hell you didn't say that? And you could have avoided all of this. Now the judge trying to seem like he's being fair, but it's too late. And Ms. Love, get your nose out the air. You caught too.
What I'm trying to say is something that happened during the ex parte matter, which is why I don't want to say it in open court.
Well, why you didn't bring it up during the ex parte matter? Why are you talking about it today? You should, if something happened during a meeting, you need to bring it up in the meeting. She wearing this bob in her head though, ain't she?
No, I'm good. Go ahead and reduce it to writing and your request to withdraw and your client, which will bring back in, your client needs to be able to have a say-so on whether or not you can withdraw. And he should get another, and
He already said
if
that he
wants to
wanted
have
her
you,
fired.
he wants to get another lawyer. So that's it. No, I'm not gonna, it's not gonna be ex parte, okay?
So,
Done?
as a result, Your Honor, if there's no ex parte communication, then I'm withdrawing my objection.
Okay,
I just want to make that clear to the court.
that's fine.
The court doesn't.
No, that's fine. You're doing your job. No, you're doing, no, Mr. Apple, I wouldn't say that one. Okay.
No, I wouldn't say that. Judge, shut your ass up. You ain't no damn good. And this lawyer over here backtracking. Oh, Judge, I withdraw my motion if y'all not gonna do ex parte. It don't matter. They still did it the other day without the justification.
Objection only with respect to this particular meeting.
Okay,
I reserve it with respect to any other ex
all
parte.
right, no problem. Okay, can we bring Mr. Copeland back in, please?
Respectfully, Your Honor, as Mr. Copeland's reiters.
Can we hold off until Mr. Copeland comes back in? Okay.
She better hope that she get a job with Love now, because she gonna need one. You right. Look, she gonna look. Why the hell you talking to the state? Look, she in over her head. She in over her head. Oh, I see. Look how he looking at her. Oh, I see. Let me go back. He looked like he wanted to do something bad to her. She won't even make eye contact with him. Oh.
Yes, Your Honor.
He knows she sold him out.
Just to put to the court on the record, it's my understanding from last week's proceedings that Mr. Copeland was actually represented by Mr. Jonathan Melnick, and that the court required Mr. Melnick to be here on Monday. And Mr. Melnick indicated that he had non-refundable airline tickets and that he would have someone appear in his place. So I believe Mr. Melnick is still this gentleman's attorney.
We don't know that. We really don't know. I don't even know if he's entered an appearance for the purposes of this, the circumstances thereof, but I'm dealing with it from the standpoint of Mr. Copeland is on the stand. He's a witness. He's had counsel. He's going to continue to have counsel. So that's the reason I'm stating this at this point in time. Okay, sir?
Judge, at this point, you be his counsel.
But thank you for putting that on the record, okay? All right, so Ms. Bumpass, file your motion. But until such time, you're going to need to remain as long as Mr. Copeland is a witness. And once we've had an opportunity to hear that, then I'll go ahead and do that. But it's not timely to begin with because he's on the stand, he's testifying. Okay, so whatever arrangement you had with Mr. Melnick, I'm sorry that that's put you cross purposes with not being able to be released. I don't know what difficulties it causes you otherwise, but I apologize on behalf of the court, on behalf of that. But
Your Honor, we did want the state wanted to put something on the record as well, that Mr. Copeland has satisfied at this point his contempt by testifying. So if he remains and testifies, then unless he wanted, there would be no purpose for an attorney. So long as he remains and he testifies, that's the only if
The prosecutor just said that she basically saying he don't need a lawyer. She's taking up for her friend, Ms. Bumpass. If a prosecutor telling you you don't need a lawyer, you better get 2 lawyers.
he pleads no purpose for an attorney. So and testifies, then unless he wanted, there would be no purpose for an attorney. So long as he remains and he testifies, that's the only if he pleads the fifth or fails to testify will he be subject to being placed in custody. So at this time, he has purged his or satisfied his contempt because he is testifying. So long as he remains in this posture, then we believe the contempt will be completed and he would not need an attorney. So, but I can't.
Well, but that's his choice. That's what the rule gives him 10 days to do.
Smart.
We're kind of saying, well, make that choice right now. We're telling him here in open court to do that. So that's what the court's concern is at this point in time.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
Boy, if looks could kill, he mad at her. And the judge really don't know the law. He don't know what's going on. The judge think that he gets 10 days, but he's saying he don't want her. And one of the other lawyers is going to tell the judge the law again, just like they had to tell the judge the law the other day. Like, the judge, in order to be so, biased and unfair, and you should at least know the rules. He don't know the rules. He getting on Google. She got her hand on her hip. Oh no, she ain't going nowhere. Now that they put that show cause on her. Now that order sign, that show cause, oh yeah.
Have a seat, madam. I'll call you back on this evening, okay? All right.
I'm sorry, Judge.
Yeah, you can have a seat. I'll call you back on this.
Uh-oh. Yeah, I think she's scared of him. I mean, he, if it's true, allegedly he admitted to murder in front of her. So she don't want no smoke with Woody crazy ass. She trying to go immediately. I just thought of something. I've been trying to figure out why Melnick was seeing NYSL Bump, but he probably never did because he really wasn't Woody Lawyer. Friday was a favorite for Steele. So then the state played the same game and had that illegal meeting, called her friend for a favor. So you think once the state realized that Bump was going to be there, they hit her up on the side like, hey, get your client, get Woody to testify while Melnick is out of town, while his real lawyer is out of town, and you're subbing, get him to testify. Well, Melnick had said that Woody's main lawyer had said that he was representing Woody like a year ago. And he said that the state knew this because it's emails from June of 23. That's what Melnick said before he left town. But you might be right. I mean, because the court is saying, even though he might be his lawyer, he never filed no paperwork. Where the papers at, Melnick? Where is the paperwork? I think when the state hit Melnick, like, who's your replacement for the day, he responded something like, if you still say that too. See, I'm gonna go back and find that because I'm gonna go back and find that one because I don't know, because when they said her name, when he said who the replacement was gonna be, I looked at the reaction of Miss Love and Miss Hilton, and they didn't look like they were just too happy when they heard her name. I'm gonna find that right quick. They both look. Let's see. I'm gonna see if I can find there were so many damn videos. This trial been going on forever.
All right, Ms. Bumpass. At this, go ahead, ma'am. You can take the podium, please. At this point, the court is still of the opinion that you need to file a motion to withdraw and give your client an opportunity to respond to that. So once you do that, and he has the opportunity to respond to it, I'll counter it, in fact, for unless he decides immediately that he wishes to not hold your or require your services, but usually he gets 10 days. So
And how would the court know if he's deciding immediately? Because
Well, usually he's hearing, I mean, you know, we have either the time passes and there's no objection that's filed and you get it immediately with, it's granted. Or I set it for a hearing and he says, yes, I either don't want you as attorney or I want to have you as attorney. I'm going to get new counsel or I've gotten new counsel.
and so Jonathan Melnick is just able to be released.
See, I don't know what the arrangement was between you and Mr. Melnick. I have no idea. That's not my purview. All I know is that Mr. Melnick was here on Friday. He said he was going on a vacation. I don't know if he even properly entered an appearance in this case. I know that his leave wasn't appropriate in this case because he asserted himself as in fact, Mr. Copeland's attorney. So, and then Mr. Melnick said that he would have counsel for Mr. Copeland on Monday, and that was you. And then you appeared on Monday. So I do think that you do need to properly withdraw and give your client an opportunity to do to have the full range of options. So until that's done, Mr. Melnick may come back and may decide, well, yeah, I'm going to pick up, and I still represent Mr. Copeland, but I need to. I'll take up that issue when it was presented before me. Okay. All right. I'm going to set that, madam, for the morning of the 25th of June at 9 a.m.
What I'm gonna do is I'm gonna pause this one right quick. I'm gonna go to the other one where the main lawyer was there before he left and got out of town, talking about he had some tickets. Boy, I ain't never heard nothing that crazy before. Let me see. I gotta mute it.
That somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it. I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this. But there's a great investigator who is looking at me and I trust her. I'd like to call her as a witness. I was told I was not there. I was told that, I forget her name. I know her first name, but her last name.
Let me fast forward. Still gonna be all day.
And I may be wrong.
Let's see.
Heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior. Statement. I'm reading from Mr. Copeland.
Okay, I'm gonna fast forward a little bit.
You know,
I believe that there's probably influence counsel. Motion.
I want to see if we can hear from
and I'm going to get a feet.
Okay.
Giving a.
we're gonna
He
see.
can make a decision. He's already.
Let's see. I want to see if we can hear from
away from. Don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So.
The defense has done nothing.
I didn't say.
here we go.
Where the full, and I.
Here we go. This is his main lawyer,
Mr. Melnick.
Here we go.
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the State Bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who.
So, based on Kenneth Copeland's main lawyer, his original lawyer, the lawyer said that I've been in communication since June 5th, 2023. With Ms. Love. So Ms. Love knew Kenneth Copeland had a lawyer, yet she still chose to talk to him. And it's against the rules for attorneys to talk to people that's represented by counsel. So if we know somebody have a lawyer, then we need to be talking to that lawyer and not to that person. Just so it don't be a disadvantage, because I mean, it won't be fair for a professional lawyer to be talking to a lay person, somebody that don't know the law, when you know they have a lawyer. So that's why he's saying he's going to report Love to the bar. So apparently it seems as if that man, Melnick, was representing, Woody, Kenneth Copeland.
Who, for whatever reason, may have some other reasons about it.
I think he's finna talk about he got to go to Disney World. He got tickets, so now he got to bring in a sub, and I think that's when they're gonna bring up Miss Bump
about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
thank you, Wagon Training 2023. I definitely appreciate that. I received that. And I'm not gonna get caught up on the numbers. I'll take it one day at a time. But thank you for that.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you, I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with them, but I suspect that they were consistent with what the dictates of 24-
yeah, I saw that.
5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning. We'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I
It
suspect
is-
that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton.
Well, if they knew the judge for 20 years, they should know that his ass being crooked. He didn't just get crooked on this trial.
And Miss Love, in particular, for a long period of time, and I don't think that they would do that to you. And
Judge, at no point did they ever.
Oh, he don't know. He said, I don't think they would do that to you. Judge, you don't know Miss Love. Miss Love would goddamn. Somebody said when they go low, you go to hell. Miss Love would go to hell and back to win this case.
Hilton and Miss Love, in particular, for a long period of time, and I don't think that they would do that to you. And
Judge, at no point did they ever reach out to me about Mr. Copeland.
Your Honor.
About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Miss Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness first because
When did you talk to Mr. Copeland?
last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us again. We showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have.
So it seemed like the state just said that she knew he was going to plead the fifth because the email told her so. Yet they still put him on the stand, and he pled the fifth in front of the jury, and that's why they are now complaining of a mistrial, because the state let him get on the stand knowing he was going to plead the fifth. And she said just as much. She got the email saying he's going to plead the fifth. I'll go back a few seconds.
With Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid, or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not.
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify.
How you know that? How you know who called who? Hilton?
So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where,
especially he don't like Fanny anyway,
where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time, is that Monday morning, I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court. We won't be having anything else.
And just for clarification, real quick, so Woody, he didn't sign for immunity. They gave it to him even though he didn't want it. So it's a thing where the state can give you immunity because they want your testimony. So once they give you immunity, whether you want it or not, you can't plead the Fifth Amendment because you're not at risk of incriminating yourself, because whatever you say on the stand cannot ever be used against you. That don't mean it can't be, they can't prosecute you some other way independent of your testimony, but whatever you say on the stand, can't be used against you. So that's the big deal. He didn't want the immunity, but they gave it to him. They said, "You taking this immunity? We're gonna put it in your hand, and we don't care if you don't like it." Because if you don't testify and you got immunity, guess what? You're going to jail.
Until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick to convey to Mr.
Okay, look, now she's finna get ready to threaten Mr. Copeland. Listen how many times she said the Fulton County Jail. She's basically telling the witness that, hey, if you don't cooperate with us, we are going to put you in jail with the rest of the people in the courtroom, the rest of the defendants. So something could likely happen to you in that jail if you don't testify. Listen how many times she say Fulton County Jail. She's emphasizing that Kenneth Copeland gonna go to jail with Young Thug and his crew, and they may, do something to him.
Copeland, that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself.
That's 2 times Fulton County Jail.
Of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until
there she go again.
The end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time. Okay. And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case, okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that.
Okay, so he said he got some personal matters that why he can't be there on Monday. And for whatever reason, he should have left it at that. He kept talking and he actually told us what was his personal matter. And it sounded ridiculous considering his client's life is on the line.
Off the record.
Okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I
look at Miss Love and Miss Hilton face when he say that.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
So this is one of those times as a lawyer that you're gonna probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel.
If I had a client and, you know, it's a situation like this, a serious situation where his client can be potentially charged with murder and all other type of crimes, and, you know, you're his attorney, then whatever you got going on, you have to put it on hold. You know, and it's part of the job. It's like a doctor or a surgeon. You can't predict when you're going to get called into the ER to operate on somebody. It might be in the middle of your child's birthday, you know, but that's part of your job. You don't just get to just say, okay, I'm going to go use my tickets because I don't want to lose out on my money. And being an attorney, why would you buy non-refundable tickets in the first place? Especially knowing that this trial was looming.
You were not his counsel, and now you are. You have put us in a situation where now you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
then that can be done, and sir, I would advise you to do that. But remember,
okay. So and I just see your comment. You saying that it's a favor for the defense, but I'm trying to figure out how is it a favor for the defense, Jiggy? I'm trying to see. Because if it's not going to do the defense any good by bringing in Miss Bump Bump, because Miss Bump Bump is the one that's going to make him testify against, you know, against Young Thug now. So I don't see how it'll help, you know, this attorney by leaving and bringing a weaker lawyer that's going to fold and, you know, make his client testify on Monday. Or maybe I'm looking at it at a different angle than what you're saying.
remember, Mr. Copeland, you know, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that, so we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I think so. I think we're going to see that in a second, because they're going to ask him who's going to cover for you. He's going to turn around and say her name.
And I need to know who.
And then once he say her name, watch Miss Hilton and Miss Love. It don't seem like they on board with it, because they both, I think they actually leaned back in their chair at the same time, like they were upset.
That lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please?
I'm gonna jump forward.
All right.
Oh. I'll jump forward too fast. Let's see. Let me back it up some.
Welcome back. The time is 2:20:35, I should say. Did you have an opportunity to talk with your client?
I did.
All right. Who is going to be here on Monday?
Caleb Bumpass.
Caleb Bumpass.
Bumpus.
Okay. All right.
Then I can state as Mr.
All right, let's go back and see how they. Yeah, let's go back when he say her name.
Who is going to be here on Monday?
Caleb Bumpass.
Caleb Bumpass.
Bumpus.
Okay. All right.
Then I can state as Mr. Copeland's attorney of record. Told him, "Are you sure this is what?" Asked him, "Are you sure this is what you want to do?" And he said, "Yes." He intends to assert his Fifth Amendment privilege again on Monday.
Okay. Well, I will. If you would tell Ms. Bumpass she needs to be here at 8:30, and we will certainly take up with that knowledge before we call our jury, and I will ask him in her presence whether or not he intends to do that, and we'll see where we go from there.
Okay.
Okay. All right. Anything else?
No conversation.
Okay. All right. Sir, enjoy your time off, okay? All right.
And now Judge finna get mad at old school. I thought they sat back in their chair mad. Maybe there's a different part. I'll see if I can find it.
We recess. Mr. Botts, you need to use the microphone, sir.
All right. Is it working now? Can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to?
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine.
He said, that's fine.
I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
He said, I already said it. So, yeah. But, yeah, I believe so. I do think that, oh, yeah, big time. I do think that the judge believed that it is Miss, we call her Bump. Yeah, I think he really do believe it's her because the way, oh, thank you, Wagon Train 2023. If y'all could hit the like button, that would be greatly appreciated. Can y'all bump the like button? Can y'all bump the like button? But yeah, from my understanding, let me see. Bring up the clip when Steele bring up the ex parte meeting for the first time. Why does Melanie tell Miss Love if you? Wait, so did Steele say that to Miss Love, or was Steele CC'd in that email? I'll go find that. So so it doesn't look like, from my understanding, it looks like Kenneth Copeland, the witness on the stand, he was in charge because he's a cooperating witness that later decided not to cooperate. So they gave him immunity to force him to testify. And he came to court in front of the jury. He pled the Fifth and said, I'm not going to testify. The problem with doing that, when a witness come and plead the Fifth in front of the jury, is going to make the witness seem like he's guilty. And obviously, if Kenneth Copeland guilty, well, he by association, the YSL other members are guilty. So they didn't want Kenneth Copeland to plead the Fifth in front of the jury, but he did anyway. They locked him up for a weekend, and then on Monday he came back with a substitute lawyer, aka Miss Bump. We know who Miss Bump is. We let me see. We had her picture up earlier. That's her. But she was out of her league. You know, those lawyers, they dance circles around her, especially that Miss Love. See, Miss Love and Miss Hilton act like they were her friend while she was substituting being a lawyer for the witness on the stand, Woody. And now they had a secret meeting in the back room, and supposedly Kayla, the lady we just saw, Miss Bump, she's the one that came out of the back room and told everything that went on behind closed doors. And now the judge is mad, saying, why didn't you tell what happened behind closed doors? He think it's her. He don't know for sure, but he think it's her. So what he did was he drafted an order. I think was it Superfly talking about the order? He drafted an order saying everybody that was in that room has to come to court and show cause of why y'all shouldn't be in jail. One of y'all snitched, and I'm gonna get to the bottom of it because I'm gonna put all of y'all on the witness stand. I don't know if this is gonna be clear enough. I've seen this on somebody's Twitter, and it's basically saying that they want Mr. Kenneth Copeland, his attorney Caleb Bumpass, all representatives from the state, security personnel. Well, he left off his court reporter, but I guess she's gonna be there by default. And he wants to know why one or more of them should not be held in contempt for disclosing information from the ex parte conversations to member of the defense counsel. And he also said, if you don't show up on June 10th, 2024, I'm going to send the sheriff deputies after you to lock your ass up. That's what he said. That's what the order said. But what somebody pointed out, he said the state, he said the security, but he really talking to Bump. He think it's her. He don't think Kenneth Copeland would have, snitched on himself that he was in the back room admitting to murder. He don't think Kenneth Copeland didn't want nobody to know that. So the only person by process of elimination would be Bump. But the thing is, they got to prove it was her. They're probably going to call her in as a witness, and they're going to put everybody under oath. But as long as her and Steele are on the same page, if she is the mole, then they have no proof that that she did it. But my thing is, I don't know if she's going to plead the Fifth Amendment, because I don't think it'll be a good idea for her to lie under oath, because Fannie and her district attorney's office will probably try to bring charges on the poor girl. Oh yeah, I'm gonna go find that clip. Bring up the clip when Steele. When it first happened, before he was held in contempt. Let me see. God, when was that? Was that the days are starting to run together? Was that yesterday? Let me see. I'm gonna find that clip when Steele first brought it to the judge's attention that he caught the judge red-handed. He caught him with his pants down, and Steele was not happy about it. Let me see. Is this it? Okay, let me see. It was so much going on, boy. And then I had made a mistake yesterday. I was thinking that Keith Adams didn't take her for Steele, but Keith Adams, which is the co-counsel for Young Thug, he told the judge, like, Judge, I am not going forward without attorney Brian Steele. So if you lock him up, you gotta lock me up too, because I'm not gonna have trial without him. And the judge was, stuck, because if Brian Steele's in jail and then Keith Adams, the other attorney, refused to play ball and he said, hey, I'm not going to participate, I'm not going to come, then the judge cannot have a trial because Young Thug won't have any lawyers there. And guess what? If Young Thug don't have any lawyers there, the trial can't be moved forward, and we're knocking on the door of a mistrial. So now the judge had to backtrack and let Steele out of jail, or let him out of the back, and say, oh man, I messed up. I gotta bring Steele back. I gotta bring him back, because now his attorney, his co-counsel, is saying that he's not gonna cooperate. Let me see. All right, I found the clip. All right. Let me see if I can just hit that button, present, share screen, boom. Is it this one? Yeah, this one.
Thank you. Go ahead. The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent.
Okay, so let's go back. So I don't think Brian Steele wrote the email. Jiggy, I don't think Brian Steele was the one that wrote the email. I think he said someone else wrote the email. Let's go back and listen to that closely.
For Mr. Copeland and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That
okay, so it sounds like Ms. Love told Woody's attorney, Melnick, that you don't represent him, and Melnick told Ms. Love, F you, and I guess when he told Ms. Love, F you, he had CC'd Brian Steele in that email.
That never.
Mr. Steele, can I interrupt you just a second?
No.
I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason
I'm asking you a question.
And
how did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 290.
I mean, he probably told her F you because how Ms. Love don't tell a lawyer who they represent and don't represent? She worked for the state. She don't got no business, co-mingling in lawyers' business as far as who we represent and who we don't represent. So that's probably like she was basically calling him a liar. He's like, hey, that's my client. Don't talk to him without talking to me. She said, you don't represent him. And he was like, BF you. What you mean I don't represent him? I'm telling you I represent him. So I'm thinking that's probably what pissed him off.
98 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No.
Look at the judge, like, I'm not going to answer your question.
I will not answer that question. Why will you not answer that question? Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based upon information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have this. I have problems right now. Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean, a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland. Tell me how you got the information. Listen, whatever you want to do. Tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it proprietary? Or information that you should not be having.
Judge, why is it a proprietary? Why is it a secret? Why you can't tell what y'all was talking about behind closed? Look at Miss Love. This a sneaky ass little lady.
Was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this.
Wait, did y'all catch that? Did he say the court? Did he say this honorable court, and then he took out the word honorable and just said this court as a diss to the judge? It sounded like he said this honorable court, and then he said, and let me rephrase that, not this honorable, just court, this court. Let me go back. That's what it sounded like.
And he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know,
Judge, ask your team. You gotta snitch. Find out which person on your team snitching.
Is why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who that. Tell me who this information was coming from. I don't want to be held in contempt.
Well, I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege unless you were in my chamber.
Okay, so I think Steele messed up here because that's not attorney-client privilege. Now, if Jeffrey Williams was in the chambers and Jeffrey Williams came back and told Steele that, then Steele has to be quiet because communication between attorneys and clients are confidential by nature. I mean, you got to be able to trust your attorney. So I don't think Steele meant to say attorney-client privilege because that don't apply.
Chambers, that's the only way you can figure out.
I tell you what,
I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
Huh?
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
He said he don't need it. He don't need it, Judge. He said, what you gonna do? But listen closely. Once the judge walks off, he's going to they're gonna try to muzzle Steele so he can't talk. But Steele basically gonna say that Kenneth Copeland in that secret meeting admitted to murder. And Brian Steele got that out just before the bailiff went over there and got him away from the microphone.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Wow, y'all heard that? Mr. Copeland made statements that he admitted to killing Donovan Thomas.
I don't need it.
Then somebody accurately pointed out yesterday, Miss Love was trying to get the court reporter not to type that. Boy, she ain't no good.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was, don't take my notes. No.
Yeah. So as y'all can see, Love was telling the court reporter quit talking, and not only that, later on she asked the judge to strike from the record everything that's still said, just in case it got in the notes. She wanted the nasty word. She wanted everything struck from the record, and I had found that. Let me see if I can show it real clear. Let me see. When they got mad at the lawyer, said that he wasn't going to be there, and Love and Hilton, they sat back in their chairs in unison. They was mad as hell.
We'll recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well,
y'all see that?
I kind of have to call him on Monday. I do.
Oh man, that attitude run thick in that courtroom. But yeah, nasty work. And y'all right. That lawyer, the original lawyer, Melnick, he probably on the beat somewhere, watching this like we watching it, saying, "Thank God I'm not there," because a can of worms opened up now, and no lawyer want to touch this with a 10-foot pole, because once you get on the case, the judge won't even let you off the case. So let's say I want to go down there and sub in for 1 day only. The judge say, "No, you're on the case now, and then you got to be here." And if you don't come back, I'll sign an order holding you contempt of court, and then we have the sheriff's deputies come pick you up, and you can go to jail with Steele and sit in the cell with Young Thug, which might not be a bad idea. I mean, and then I also want to show Keith Adams, because Keith Adams stood up for Brian Steele, and I didn't know this yesterday. I was thinking, like, why wouldn't Keith Adams? Because if we don't cooperate, if a judge make us mad and we don't show up, we go to the hospital, we play sick, then now you're gonna have to call a mistrial. And 90 days worth of work is going down the drain. If you lock both of the lawyers up, all of y'all hard work is going down the drain. So for the judge to do this, it is nasty work. And he taking the lead from Miss Love. Miss Love. She always throwing some miss, ain't she? Let me see. Damn, man, Woody was really about to take the charge, and the state won't even let him because they can't get Jeffrey too. But my thing with Woody, he can admit to whatever he wants to admit to. He has immunity. They cannot use whatever he say against him, but they can use any independent evidence. So if they can find out that he murdered Donovan Thomas without his testimony, they say, "Hey, we're going to go through and do our own investigation and piece it back together," not using his testimony, but using outside evidence, witnesses, videotapes, whatever, then he can still go down. So that's why, that little fake immunity that they offered him ain't worth a damn, especially when you still can get picked up by the feds. Who is this? Seti Nash. Seti Nash posted a video today where the judge and the prosecutor are signaling back and forth. Y'all should go watch that. I don't think Steele going to jail. His wife and Merchant have filed motions. So what can happen to the judge and Dominant? Not Dominant Silk. Wait a minute. If Dominant Silk was them like the Trump people, the build that wall. And was that the two women? I think one of them passed away now. It was like two sisters. Maybe I got it wrong. That's what I thought. That's what I thought. I could have it wrong. But yeah. Yeah, but one thing about Miss Love, she didn't want no parts of Ashley. When Ashley came in that courtroom, Miss Love, she be all up and down on when the men talking, but when Ashley came in there, she sat her ass down, and she know why. Because Ashley is a giant slayer. I don't care how rough and tough you think you is, Miss Love. I don't know if she want to be strong. She cutting her hair short. The old folks in Texas used to call. I ain't gonna say it. I'm not gonna say it. I don't know what she thinks she was, but Ashley is a giant slayer. Ashley came in there. Ashley took down your boss, Fannie Willis. So if Ashley can take down your boss, you know damn well she can take down you, Adrian Love. She's the reason that the Trump trial is paused. Ashley was the one going back and forth with Love, big sis, Miss Fine. Yeah, she was the one that had her on the witness stand, making a fool of herself. So yeah, still knew what he was doing. He brought in the big guns. And Miss Love sat her ass at that table and didn't say a word. Let me see. Found your channel today. Gonna subscribe for sure. Oh, thanks a lot. Definitely appreciate that. I didn't know so many people be up this time of night. I don't know what time it is wherever y'all from. Ashley was the one going back and forth. Oh, okay, yeah. So let me see. I wonder if we have that when Ashley came in there and just, and shut it down. Because Ashley wasn't finna, she wasn't having none of it. Let me just sum this up. I think Brian, the judge, came back out. Brian said he wasn't going to do nothing. I think I want to play that just so I can give Keith Adams his vindication, because I definitely thought that he wasn't standing on business. I thought he was going to let his, co-counsel go down alone, but that wasn't the case. Keith Adams said, hell no, Judge, F you too. If you're going to take him to jail, you're going to take us both to jail. And then it's going to be a mistrial for sure, because Young Thug won't have any lawyers left to represent him. Let me see. Share screen. Share. Which one is it? So many channels. We all seen this. He won his answer. Right. And still is still going to say no.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know.
It would have gave me joy just to call out his corruptness.
Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
Trying to fire somebody and ain't paid that woman $1. Boy, that tripped me out when people be trying to do that. How you gonna fire somebody?
Or you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't happen.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte?
You're acting like it's ex parte under
It's
seal.
ex parte. It's
Now, I will say ex parte is only for, unique situations. Nothing, it has to be something very out of the ordinary for ex parte communications. Let's say the witness, Woody, is saying, hey, Young Thug in jail threatened me. He said if I testify, I'm going to be killed when I go back to jail. Then obviously that's something that Woody and his lawyer don't want to go back to Young Thug. So they may try to make arrangements to talk to the judge secretly about that, and then maybe get Woody moved to another jail. That's something that's an ex parte. You can kind of understand that. And if something like that was to happen, the judge doesn't have to let the defense know, because obviously if they let the defense know, the defense can tell, Young Thug, the lawyers can tell Young Thug, but they can at least tell the lawyers like, hey, an emergency matter came up and I had an ex parte hearing with the other side without y'all being there. I can't tell y'all what it was about, but I did at least have a hearing that's recorded on the record, so y'all can, preserve y'all error for appeal in the future. But that was nothing like that. It was no threats on this man's life. They just had a secret meeting and got caught. And there was no reason that the defense couldn't have been there.
No, it's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is, how did you get this
Judge, he said he's not gonna tell your ass. Why you keep asking?
information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at Common 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
Saying the judge that violated the whole goddamn Constitution.
But just listen to what I'm trying to tell you. You're saying,
see,
you're threatening me with contempt.
privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you.
Damn, it even looked like the cop was mad. The cop didn't even want this to happen. It seemed like the cop walked by. He shook his head. Let me go back. He was like, "Damn, Judge, why are you holding this lawyer in contempt?"
No, that's not what I understand the rule to be.
I saw that little head nod.
No, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, you're
No, he don't. No, he don't. As of right now, he didn't know. Now I think he know who it is because it's the next day. Well, he think he know who it is. But right now, listen to his explanation. He's either going to say, I think Brian was eavesdropping, or somebody told him.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're
it's wrong.
Asking me to listen. I told you the first time, and I'm not.
Sir, I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not.
See, so he's saying he thinks Brian was eavesdropping, which is a crime. I mean, you can't, eavesdrop. So at this point, Brian could have really asserted his Fifth Amendment privilege against self-incrimination, because now the judge is accusing him of a crime. So you don't got to even say attorney-client privilege, work product. You can say, hey, I'm going to assert my Fifth Amendment right, because the judge said you're eavesdropping.
Not meant for you to hear at that particular point in time.
Judge, you listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we'll.
Okay, well then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you.
But you're assuming.
Okay, so he said he was eavesdropping. Now he thinking somebody parroted, somebody told him that. So, Judge, you just said you thought you know, but now you just gave two different reasons or two different ways you think he could have got the information.
Mean something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our.
Look, Love going to go call Fanny. She going to go call her boss. Like, hey, the judge finna mess this trial up. He's trying to take a lawyer to jail, and it's definitely going to be a mistrial. That's why Love just jumped up real quick.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all in the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele. That is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read the
not only sworn, unsworn.
Okay, I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way.
Okay, so somebody disclosed it, so we're not eavesdropping anymore. Judge don't know. Judge is guessing.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we?
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love.
So we already know Ms. Love, she gonna get up there and say the same thing the judge said. She basically gonna tell, I'm gonna speed her up quickly. She basically gonna tell the judge, hey, judge, we need to know. We don't know how to proceed because we don't know who told. Basically egging the judge on. Y'all know how she do. And then she gonna say the same thing 4 or 5 times. She is talking circles.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
Okay, all right. Yes, ma'am.
Your Honor, I am disturbed by Mr. Steele's.
Your ass ain't disturbed. You as crooked as they come. Talking about she disturbed. This is funny.
Am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer.
She's talking about obviously Kenneth Copeland and Woody. Kenneth Copeland and Kayla Bumpass, the substitute lawyer. And I think she's gonna tell us what they was talking about.
Know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we asked that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon.
See, look, she's talking about what they talked about. So if it was so secret that you didn't want the public to know, why are you telling? If you didn't think you did nothing wrong, Ms. Love, why are you now saying what y'all were talking about? The only reason you're saying something else is because y'all got caught.
A person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants,
why does it matter?
We cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant.
Why you need to know that? I'm not understanding why she need to know that. What purpose will it serve her?
We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask.
What? Wait. Y'all heard her? She said, we didn't do nothing wrong. We didn't do nothing inappropriate. But if need be, we will reach out to the state bar and ask. Ask what? I mean, you say you didn't do nothing wrong. There's nothing wrong with secret meetings. Why are you reaching out to the state bar and ask? If anything, you need to reach out to the state bar and confirm that what y'all did was illegal, legal and justified. But you said you're gonna reach out to the bar and ask because you know, and she being real careful with her words. Oh, let me see.
Be appropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, or the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people.
Starting with yourself.
That I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was.
You know what it was.
It was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice.
I'm within listening shot. Hey, are y'all within listening shot of his voice?
Accurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as we're standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Oh, please, come on. Let me help you, Ms. Love. Let me help you. I'm going to speak you up.
Ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
Look at her. She's sitting there like she the victim, and she was back there meeting in the dark. You can't make this up.
Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele.
Look, she worried about who Mr. Adams represents. She worried about who the lawyers are representing. Don't worry about who he represents. He know who his client is.
Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt. Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams. He has 2 attorneys.
Okay, yeah, he does, but
the court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial.
Wow, so he's basically saying, hey, I know exactly what Mr. Steele knows, and I'm also not telling you. So he's basically telling the judge, you got to hold me in contempt too. But the judge knows if he does that, then Young Thug won't have any lawyers left to represent him. So the judge already know he can't hold him in contempt. That's why the judge is going to say, no, I didn't ask you, I asked him.
I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, so
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things.
Oh yeah, he'd get in trouble.
So I'm not going to throw out spurious allegations.
He doesn't have a boss per se, but he is regulated by the Judicial Code of Ethics, and he also is an attorney as well. So he's, in order to be a judge, you have to be a lawyer. So if you get in trouble with those two departments, then you can find yourself sitting at home and not on the bench.
Like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that.
So we get it. I think Adams is gonna come back up and he's gonna flat out tell the judge, like, Judge, I'm not gonna go forward. Let me see. I think he's gonna tell the judge, I'm not gonna go forward without Mr. Steele.
Is Mr. Adams in the hallway over there? Could you get him, please?
Cause the judge looking like he know he messed up. Come on.
Thing was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that
Let me see. I want to see when Adams come back up. Cause he's basically gonna tell the court, like, I'm not going to continue. Y'all gonna be Young Thug is gonna be sitting at that table by himself because I will go home. Did I go too far? Let me see. I might have went too far. Maybe I didn't. Cause I think Adams must have told him from his seat.
Go forward. We've had plenty of, and I don't doubt that won't continue. You can certainly get competent counsel, which the court finds. Have your entire defense team, and I don't doubt that won't continue. So you don't get to have your entire defense team here. You can certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you
Yeah, so he's directing Adams to continue and watch what Adams say.
Continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you.
You slow it down. So we can hear what's going on.
You to do that and continue to do that, but
Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect that the court has to do whatever it is appropriate, but I would ask that the court also respect my representation as Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a free trial, and we believe that that's sufficiently great. And I would respectfully decline the court's order to continue forward.
I will respectfully decline the court's order to continue forward.
Your Honor, may I?
And now the judge is stuck. You got a lawyer that's in the jail cell in the back in the holding cell, and then you got another lawyer telling you that I'm not going to go forward without my partner. So now the judge is really stuck. I mean, the judge can throw Mr. Adams in jail, but now Young Thug's going to have no lawyers. It's going to be a mistrial. And now Miss Love, what she's about to do, she's not trying to help Steele out. She's trying to figure out a way to get out of a mistrial because she don't want to start all over. You know, her career is riding on this. So she's going to suggest to the judge, to let Mr. Steele out, let Brian Steele out, let my people go. That's what she's going to tell the judge.
Sure.
Address the court. Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that
From the court, how it is that the state has any position in this particular conversation between the court and myself.
Before we recess, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir.
He asking his side piece to help him out.
Okay.
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that
wait a minute. She's saying that this little 30-minute back and forth needlessly delayed the trial of the case. This trial been going down there 100 damn days. The judge took more days off than any judge I know. He takes more breaks than any judge I know. And she's gonna accuse the defense of delaying the trial because they taking up 30 minutes to complain about something that the judge and the prosecutors did behind closed doors. And now she's backtracking. She wanted still, he should be held in, the appropriate remedies, hold him in contempt. But now that Mr. Adams not playing ball, now she's backtracking. Oh, judge, don't hold him in contempt. Hold him in contempt later. Hold him in contempt on the weekends. But we need him back out here right now.
it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session, physically.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record.
What now, lady? What the second thing? God damn.
Is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or.
Okay, so she lied. So basically what happened, we all know Woody was in the back. It was Woody's lawyer, the court reporter, the judge, some security officers, and the state, Ms. Hilton and Ms. Love. And we all know the state pressured Woody to testify. He didn't want to testify. And they were saying, hey, we're going to hold you in jail for 2 years. You're going to be in Fulton County Jail, and you're never going to get out unless you testify. Because even after this trial is over, Ms. Hilton said we have other defendants that haven't been prosecuted yet. So until all those trials are over, you can be held in jail indefinitely. So they were back there bullying him. And even the judge was threatening him, saying, hey, I'm going to lock you up, so you better get out there and testify. So that is important to the defense attorneys. We need to know that a witness is getting cornered by the judge and the prosecutors behind closed doors. And now she's saying, oh, that's nothing. That's not material. We were just talking about the weather. We were talking about what we were going to eat for lunch. No, B, that's big time, material.
Case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may substantive communicate on the record, is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed.
Something substantive was discussed because apparently Kenneth, they pressured him so much that he literally confessed the murder while he was back there with them. And that's something the defense attorneys need to know about because, my clients are on trial for RICO and, y'all accusing them of all killing somebody or being a part of this organization, being a part of this murder when Kenneth Copeland took the blame for that murder. So when it's time for the defense attorneys to cross-examine him, when it's their turn to question Woody, I need to know about what Kenneth Copeland confessed to behind closed doors when he was pressured by the state. So it's definitely the defense attorney's business. She's making it seem like, oh, it's none of their business. We were just trying to get him to testify so he don't be held in contempt. No, but you're not telling everything else that went on behind closed doors.
Everything was recorded and the representations.
Well, play the tape. Play the tape.
Made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred and that person relayed that no substantive communication took place during that meeting.
Wait. Hold on.
What is she saying? And that person was told that person is
I gotta go back. She's saying something
when questioned, or is that persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred and that that person relayed that no substantive communication took place.
So it seems like somebody asked Miss Bumpass, Miss Bump Bump, what happened back there? And it seems like Miss Love is saying that Miss Bumpass said nothing substantive happened back there. If I'm getting that right. So maybe Bump Bump is not the leak. Let me just one more time.
Persons who were present was recorded, and the representations made, at least by persons who were present to the state.
Okay, so that's Woody's lawyer made representations to the state.
Is that when questioned or
Woody's lawyer is saying that she was questioned,
queried about it, that person was told
Woody's lawyers was told, or Woody's lawyers was asked what was happening behind closed doors.
Asked whether things occurred and that that person relayed that no substantive communication took place.
And Woody's lawyer said no substantive communication took place, okay?
During that meeting. So that is the second matter. And first and foremost, we just ask that the court again allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Listen, Judge, that's fair enough. You don't have no fucking choice. That's fair enough.
Session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay. Mr. Sharp?
Brian still should have stayed in the back. I would say, no, I'm held in contempt. I'm not coming back out.
Ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with, sir. That doesn't alleviate the information or make it less valid or invalid. So because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded.
And they don't trust your word anymore, Judge. That's what they're telling you. We can't trust what you're saying. We need to see for ourselves.
If you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's great.
And like I said, if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
my client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
Okay, and that's your argument, sir. That's your argument. That's your argument.
Ms. Hilton, she rubbing her hands together. She know they effed up.
Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept.
Or yours, Judge. Or yours.
The court's representation. I'm telling.
We do not accept Ms. Love's representation.
Okay, you don't accept the court's representation. I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by.
Okay, somebody asked that question. You see, he answered that right there. There's other bodies that his conduct can be reviewed by. So he definitely can get in trouble, and the judge know it. Let's go back to what he just said.
Then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay, well, at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. Not saying that
the judge really got an ego problem. He still want to know. He would not let it go. He's not going to let it go. He keeps saying, I want the information. Golly, this is wild.
May or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure. So, and
forget y'all constitutional rights. I'm just worried about who the mole. Who is the mole?
The court's concerned, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
Okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
The only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe in the application duty that the transcript is in.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please.
So I guess Mr.
Put his tie back on.
Put his tie back on. So I guess Steele gonna come back and do his Woody is the most. See, that's interesting because I've gave that some thought, but
and then we'll go ahead and get started at that point in time, okay?
But I'm trying to figure out would Woody want the world to know, especially Donovan Thomas' family, that he is, he's the one that admitted to killing. I mean, who would he tell that to? That was my only issue. Like, why would Woody come out and and let it be known that he admitted that he self-snitched on himself in the back room is one thing, but then on top, he was back there talking, and then on top of that, he admitted to a murder. So that's why I was like, is it Woody? Or did Woody, maybe Woody's still cool with Young Thug and them, and maybe he told one of them and they told their lawyers? Maybe he said, hey, I took the rap for that murder since I got immunity. So, and maybe they told their lawyer. It could have been Woody because it was a break in between that time period, unless they had Woody in a personal holding cell. No, but it could be Woody because Woody was listed on a show cause order. Let me see. Yeah, to include the witness, Kenneth Copeland, his attorney, Caleb Bumpass, all representatives of the state and court security personnel. So yeah. So yeah, he was it could be possible that he was the mole. But they're gonna get to the bottom of maybe. If everybody go to court and say, hey, we don't know nothing, then the judge is not gonna be able to beat it out of them. But I think they came back out, the trial continued, but I had wanted to see Ashley's part because Ashley came in there, what that girl say, like a wrecking ball. And Kenneth Copeland, Woody, he got on the stand today and showed his naked ass. He act like he couldn't read, he couldn't write. Let me see. Let me see if I forget. I think the judge was even low-key scared of Ashley. They knew who was walking in there.
I don't even know
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
I didn't call, but.
Okay, and that's,
Let me just finish.
okay.
Because you said to me that you figured out somebody told me this information and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any space, Mr. Steele.
Oh, y'all got space in there. Y'all got space for everybody else. Y'all got some space in there. He don't want all them lawyers in there because he know the lawyers know more than he do, and he about to find that out the hard way apparently.
And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. We'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant is present.
All right.
Oh yeah, because that case, probably gonna live and die on his testimony. And so far, he not really cooperating. I watched a lot of it today, and he is really just talking in circles. He's defiant. He don't want to answer questions. Yeah. Coming to
Ms.
Ashley.
Merchant, good to see you as usual.
No, it ain't.
I have told your client, you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know.
Look, he still want to know
who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedious.
Okay, he said criminal contempt. Remember that, criminal contempt, not civil, criminal contempt.
Bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and is very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that
he told you hell no for the last time
that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please. Microphone, it'll pick up, madam.
Thank you so much. Just for our Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well,
okay.
Okay, look, the judge, look, he sat back. He think he know what he's talking about.
Just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require a recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia.
Oh, look. He thought she was going to be ready.
App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again.
215 Adams and Hasty. Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding. So most of the cases are a little bit older. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told.
Look at all that space along the walls. Back in the day in the small churches, we stand along the walls. We gonna get in there. He don't want them in there.
Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed to.
I don't want them in my jury box, okay?
You don't want them in there.
I understand. And we're here on behalf of Gackel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association.
Not the strike force. The strike force. They finna strike his ass.
Of criminal defense lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susor. Alex Susor. Thank you, Judge.
And we all know who Ashley is.
Henry Adams,
She the lawyer.
It has two issues. One is the motion for disqualification. Okay. And that's and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372.
Yes.
The other case, just a second.
And there's several others when you're ready.
Several others. Y'all see Miss Love? She minded her man. She ain't jump up once to help out her man. Thank you to the man. See, still he's standing on business. What that girl say? What is it? Gorilla Glow? She said, before I let these hoes play with me, I'll go eat some jail food. And that's exactly what Brian's still gonna do on Friday. Come on, Judge.
Have two.
Try to speed it up.
Court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
so those were only the initial two. I had a couple others.
Okay, go ahead.
As well, yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also.
You said 279 Georgia what? I'm sorry?
Georgia 13.
Georgia.
Y'all see how old these cases are, like you said.
2005 case.
Right.
And it defines direct.
It's rare for attorneys to be held in contempt, so a lot of these cases are old.
Contempt, and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
Look at her drinking her smart water. Look at some of that damn
See,
water.
you're all covering under. Let me see.
I'm sorry, Judge.
Hold on. Just a second.
I'll cough it up. Miss Love, why you not helping your man out? What's going on? She ain't even looking Ashley way.
Opportunity to speak in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me, I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial.
Exactly.
So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, Mr. Steele has a right to make a motion like this. If there were ex parte,
he does.
But
I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you. Okay.
If she know like I know, she'll keep her head down. God, Ashley went and found the money under Fannie Willis' mattress. She knew who Fannie Willis was sleeping with and got her boyfriend kicked off the case, Nathan Wade. Miss Love don't want this woman getting in her bed sheets and figuring out who she had over there. She better keep her damn head down and act like Ashley don't see her in the court.
Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know.
He still want to know. He would not. Who sing that song? I want to know what turns you on. So I can be the one who always makes you.
Who told him this? That's all. I'm not asking him to release or otherwise.
Joe, I want to know Joe.
Tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted.
I want to know, Joe. I didn't even know Miss Hilton is snuck her damn ass off.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Yep. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because
no, tell them we don't even need to get there. Why? Tell us why, Ashley. Tell us why we don't need to get there.
He can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications.
Ooh, telling him off in his own court. Old folks say that's how you do it, nice, nasty. She ain't cussing him out, but she telling him, you was the one that was in the back room doing it. You a witness to the case. You was in the wrongdoing just as much as Miss Love doing. So yeah, we in here, and we in here deep.
They can't be ex parte if you weren't part of them, by nature.
Okay. Well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay,
did he say that at the beginning? He said that at the beginning he was eavesdropping. Now he's backtracking.
That one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all.
No,
I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Check that
Judge,
out.
let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he should.
Hey, I'm actually off tomorrow. I don't have court tomorrow, so I think I'm gonna jump on in the daytime as well and see if I can get a little bit of it live. Oh yeah, I'm free the whole day tomorrow.
Shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things.
She said quite a few other things. So sit down and sit tight.
All, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore,
Miss Love, Miss Love said she want to jump. Miss Love didn't grab the mic. Hold on. Please say something, because I won't ask you to get on your act. Please say something.
Yes, to the contempt. To the contempt. You are a witness to the contempt. So you have
never mind. She folded back up. She went back to that neck.
Now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge.
Oh, a fair and neutral judge. What's she telling him? You're not fair and neutral. Ooh, that got to be embarrassing for a judge to tell a judge to his face, you're not fair and neutral. And you've been on the bench, 20-some years? That's embarrassing.
To those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding.
And a judge who is not also corrupt.
Deciding whether or not he's in contempt. This needs to be heard by a different judge.
Oh, he don't even know what to say.
Mm-hmm.
Drink your water. Drink your water. Hey, I'm going to drink some water with you. God damn it.
He has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now.
Well, get it goddamn done. What you waiting on? Tell him, Ashley. What are you waiting on? So I'm gonna do that right now. I know damn well you is. They not playing with you, man.
Okay.
We need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record in this case.
Come on. And then the judge, he still got the contempt wrong, and they're gonna explain it to him. He still thinks somehow this is criminal contempt, and they gotta explain to him this is not criminal contempt. This is actually civil contempt, and the judge don't know the difference between the two.
He has filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself with the contempt just by telling me who it was, and he can do that this evening.
He still want to know, not the dog leash. I don't even think goddamn Jack want to go home with him no more. Jack said, "You embarrassed us both, big dog. I'm gonna chill here." Ashley, matter of fact, that's Ashley dog. Now, Ashley, take your dog home with you.
Do it. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on.
Well, he's still begging. Why are you begging another man to tell you what he knows this many times? After he told you no, that he's not gonna do it.
On Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
And you don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on.
Right.
Look at Miss Love. She playing on her phone under the table. And I bet you Fanny won't come storming down there tonight. She said, Ashley down there? Oh, hell no. To the no.
In the presence of the court. The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
That's correct. You see how he said it low? Look, he know. He said that's correct.
The judge, that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Well, Judge, I think I'm addressing a slightly different point of law.
It is. Hold on. One second.
No, I don't think you. Black Air Force One, nah, they white. White as snow. He ain't about that life. You can tell right now he's scared. He's tipping around trying to find some law to back him up.
Give you two cases. One is
It's Utenema. It's a UNTEMA
She
versus
texting her.
Smith, and that's 371 Georgia Field 19.
She said, "Oh my God!" She said, "Hell yeah, y'all on your own. Don't call me, put me in no bullshit." Yeah. Exactly. He be trying.
Which was decided March the 12th of this year.
And watch him get
It
showed up.
covers the
Let me
differences
speak to
between
that.
the
Let
types
me
of
get showed up.
and that is Henry when July.
Citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me what the basis of the conversation was. Who? I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's I respectfully, I would want you to, in Ray Hughes, which stands for the same point of law, civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his
Get him, Ponytail. Get him.
Client. So he is being placed in a position where he's either going to jail.
Wait, when Miss Hilton snuck her back in, and she covering her damn face up,
or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's
right, and he know Love can't help him because she really ain't got a say in this. This don't affect her at all. So he can't even look to her for help, and they double teaming his ass. Yeah, I do agree. At the Trump hearing, you know, everything in moderation. When you go on too long, then okay, now you start it's starting to be a bit much. But I mean, she did enough to get Fanny. I mean, she drug out the dirt to where even Nathan, she brought out Nathan's divorce. God damn. Ashley, don't bring your ass down here to Texas stirring up no mess.
in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is.
He told the judge, yeah, but you got it backwards.
Follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the
which is, I believe, we got it backwards.
What the privilege is the conversation.
Not only backwards, ass backwards.
Didn't ask him about that. I wanted to ask him about who the person.
And
Okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly.
Don't scratch your head, Judge. Don't scratch your head.
And you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Oh my God.
Think about it.
Trying to punish you. You get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Thank you.
Okay, all right. All right, so we'll be in recess about 5 minutes.
That's wild. That is wild. Y'all see? Y'all see? When will it be called a mistrial? Oh, never. Not as long as he the judge. He's not gonna call him mistrial. That's for damn sure. Yeah, his pride on the line. He don't want to be the judge that lost a trial like this due to a mistrial, due to something he caused. He'll never recover from that embarrassment. I don't think he'll recover from this embarrassment because the world has been watching, and we can see that he's, he ain't on the up and up. He not above board. Sad part is that doesn't stop the trial. It only prolongs and makes them have to suffer even longer. Instead of him making the right decision and granting him, no, he's not gonna grant him this trial. He'll tell them all to go to hell before he grant a mistrial. Go to hell. Calling him on his stuff and my son 1 hour. Yeah. 1 hour later, I don't think he came back till later on that night. And then he took an hour recess to call Dirty Fanny. Yeah, he called her because he took forever. So I'm thinking he didn't know what to do. So he calling these different people, maybe some other judges that got more sense in their head than he do. And they trying to figure out, like, what can we do? And then they came back and said, okay, he still needs to be there in trial because if you take him out of trial, then his partner's going to quit the trial, and then, it'll be a mistrial for sure. So they came up with the idea to put Steele in jail on weekends, and Steele being a badass, he said, Judge, I'm not scared to go to jail, but I still need to talk to my client. So can me and my client share the same cell? What? Yeah, but a higher court, they normally won't step in at this stage. When a higher court review a case, they don't like to double work. They want the case to be over with and they get the whole file and then they will review it. They don't want to just step in right now unless it's something so egregious where they saying, okay, enough is enough. But I don't think it's to that level right now. Now if it's something like insane, let's say the judge lost his mind, he's having a mental breakdown, he's showing up drunk, and the trial just impossible to go on, then the appeals court can step in and sit him down. But like an interlocutory appeal, like right now in the middle, I don't see them, inclined to do that. Especially, we got to remember, this is right now they're trying to work on the Trump case, and they told that judge that like right now, while we're trying to decide this appeal and figure it all out, you can't do anything else in your court. And the Trump judge was trying to still go forward while the appeals court was working. And they're like, no, when we working, you be still. They say be still. When it's thundering and lightning outside, they say be still while the Lord is working. So they say, hey, while we working, you're not gonna be able to do nothing, Scott McAfee. He should get recused. And see, in some jurisdictions, you have like a high judge, administrative judge that can step in when something's getting out of hand. It can reassign a case or move it. But I don't see that happening. You know, and I believe, I'm not sure the structure of Georgia, but I believe he's the chief judge. And I think he became the chief judge just by being there the longest. I don't think it's based on his ability to actually try a case. Yep, it was an hour later. He deserves every dime. Still is. Oh yeah, like someone said yesterday, the price went up for him. Like any defendant ought to be honored to have him as a lawyer. He would go to jail for you. Not only go to jail for you, sit in a cell with you. Somebody said he did that because he needed protection. Who the hell gonna mess with Steele in that jail? He's not a prosecutor. He don't lock people up, so they didn't like people in there after him trying to get him. Lee says this judge is the chief judge. He's slipping and should consider retiring. Oh, what? And I know I had caught a little bit of Lee's first live when he first started covering it. And I think he had some reservations because, you know, he has a relationship with that judge. Well, I don't. I'm going to call you out. At Texas, all the lawyers that have been practicing, yeah, he should retire. Hell yeah. Yeah, it's time for him to go. I mean, they say he got PTSD and, you know, his dog is there to comfort him. He can take the dog, like you said earlier, and just go home. Call it a day. Take it now. Retire. Pick up the dog leash. Pick up the leash. And say the hell with this. Y'all can have it. I heard that 20 lawyers have filed with the appellate court already. Golly. Still is a real MVP asking to be in the same room with Jeffrey. Oh, hell yeah. And the judge, you know, it's not like the judge wanted to grant Steele's request, but he really had no choice because Steele is saying, if you're having me in jail and I can't confer with my client, that's another reason for a mistrial. So if you're going to have me in jail, then I need to be with my client so we can discuss our case, which is like real good because this is really beneficial for Steele and his client, Jeffrey Williams, Young Thug, because now they can really talk. They have more time to talk, you know, day and night on Friday night, Saturday night, and Sunday before Steele gets out. They have time. The judge was scratching his head, mumbling, looking every direction once his questions were being asked. Yeah. Yeah, he didn't know what to do at that point. Anybody got a camera, a microphone, a phone they want to talk? Or everybody in the bed with their robes on? With the rollers, I don't think people put rollers in their hair no more, do they? The rollers, the bonnets. The headscarf. Come on, take us back. I remember when it was cold, my grandma didn't leave the house without a good headscarf on their head. They don't do that no more. He better share his commissary because if he don't, guess what? Still can make his life a living hell. I mean, obviously you don't want your lawyer mad at you, right? Still be like, you know what? Keep your commissary. You're gonna be here for a long time. You're gonna be here for a long time because I'm not gonna work as hard when I get back to court. Since you don't want to share your Oreos, since you don't want to share your chocolate chip cookies, your Doritos, and your cup of noodles. He said, you don't have to share. So I'm assuming Woody is coming back tomorrow. He came in today and he showed out. Ooh, he showed out. And Miss Hilton, she kind of antagonized him. I mean, I think she tried to get a rise out of him. Oh, one part, she kept walking up on him when I was watching it earlier. Let me see if I can find that part. And I said, woman, if he wanted to, he can grab you by your hair and slang you by your box braids. Because she kept getting too close to him. And then at one point, I think he was going to sneeze or something. He said, back up. When I tell you Miss Hilton got so far back when he said that, let me see if I can find it. He said, back up. I don't know what that was about. He kept, I don't know if it was her perfume or was he allergic to her or I don't know. Was he trying to insinuate that she stunk? I don't know. Let me see if I can find that part. But I know Miss Hilton, one thing about lawyers, we believe in notice, and he gave her fair notice. It's gonna be hard to find that particular part. Let me see, because she kept walking up there so many times. Yeah, they say Woody would be there for a few weeks. Like what's that man named Tick? So they're gonna be bringing in. I don't know if he's gonna be able to survive a few weeks because his patience is already getting thin. He was coughing. Judge was coughing. He was making face. Yeah, his patience is getting thin. Like Miss Hilton told him to stand up and then sit down. He said, "We ain't finna do all this up and down. We ain't finna do this up and down." I'm trying to see. I mean, let me see. And I know somebody over. One of y'all got y'all got more insight on this case than I got. I know somebody got something to say. Let me see. It was one part that was funny to me. She treated him like she treated him. She got the she got the stick in her hand, like she trying to teach him how to read. You think he pretending? Because he did say that he only went to elementary school. Did he say middle school maybe? Nah, he can read enough because I think he be out on Instagram. Let's see.
It look like an R.
Mm-hmm.
It looked like an R. You know what an R look like?
An R.
Mm-hmm. Oh, excuse me, yes.
Love.
All right.
Miss Hilton so shady.
Bye.
Mm-hmm.
Me.
Okay. At Woody 372. Is that you in the picture? Is that you? Is that your Instagram name?
No, my Instagram Woody is Woody versus Woody.
Hey, I was watching
In
a little
2014,
play. Why
was
would the
that your
Mo
Instagram
be jailed for exposing corruption?
Not that I recall.
Not that you recall. All right.
See, I don't think he said he went to high school, or unless he lied.
I want to go to.
But the thing is, they let him out of jail that same day.
As 164 Echo Hotel.
I'm trying to see.
I need to stand up again.
You may have to.
Uh-oh. I think what he gonna say, we ain't gonna be doing this up and down.
You sit down right now.
Uh-oh.
I'll tell you when you can get to stand up.
We're not gonna do the up and down.
Right now.
I heard him. He said we're not gonna do the up and down. Also, he was lying.
You sit down right now. I'll tell you when you can get to stand up.
We're not gonna do the up and down.
Right now.
And look at Ms. Hill. We might have to. Now, if he was to grab your
Want me to
ass
read it from the side?
and turn you every which way but loose, what
Who's
you
in
gonna
this
do?
picture? Can you see it on that screen next to you, or you need to turn around?
You talking this picture right here?
Yes.
There's me and Young Thug.
All right. And
I want to see when he
scrolling down.
sneezed, or I don't know what he was doing.
and going to the take-in, do you see that same year of 2014?
Let me see. Is this it?
I'm in some picture by myself.
Some by yourself and some with Mr. Williams, right?
Right.
So my question for you is, all these pictures that have Mr. Williams in there,
Okay.
Can you identify them for the record, please? Which ones you talk, which 10 pictures you're talking about?
What he say?
he just wants me to call these numbers out for the record.
I was watching a little replay with the Moby drill for Coach Russia going on in the
And
jail.
we're looking at 348 Yankee. I'm trying to do an order for the record.
She said 348 Yankee.
We're looking at 348 Yankee, 368 Yankee, 369 Yankee, 370 Yankee.
I will say it
371
depends.
Yankee, 372 Yankee, 164 Echo Hotel.
Okay, I think we're finna go.
Yankee.
Okay, let me see. I think he's gonna do it now.
164 Echo Hotel and 164 Echo.
Get back.
Get back. Get back. Look, she got all the way back. He said, get back.
164 Echo Hotel and 164 Echo.
Get back.
And then he already told her he don't drink water, and then she tried to take him some water.
All right, well.
Excuse me.
Excuse me.
I'm sorry, can you take a break?
Nah, I said excuse me.
Oh, okay.
Looking at these pictures. Echo Lima. Were
Yeah,
these pictures
his temper is getting real short. Real short.
taken in and around the same time? So that's my
He
question.
would have grabbed a microwave
When I
and,
took all these pictures.
and spun her around
Around
like a
the same
helicopter
time?
in that
Around the
courtroom.
same year.
I would have been done.
2015.
They should have.
I would have been
Okay.
done.
So we're saying that these are taken around 2014, 2015.
Big witness.
I'm not being specific when they was taken. I know they these pictures right here, the one that
So I will say, so they trying to figure out how the person found out, because we don't know how they found out. Now, if they got a recording device in the judge's chamber, that's illegal. If they were eavesdropping, I think still quoted the law, that's illegal. But if it was somebody in the room that came out and said something, then it's going to be hard for them to prosecute that person, because I don't know what law they will be accused of breaking if they are in the room. Now, so if I'm in the room and you say something in front of me and I come out and say what you said, I mean, I'm not under a gag order. So what law would I have broke? Now, it might be other rules. If it was Woody's substitute lawyer, Miss Bumpass, Miss Bump, and she came out and said something, maybe that can be a problem, because if she's supposed to be representing him, Kenneth Copeland, why is she coming out telling the defense attorneys, what Kenneth Copeland said, that he confessed to murder? I mean, obviously that's something you're not supposed to tell, other people if your client admitted that in confidence. So, I mean, she could have issues with the bar. But as far as somebody going to jail, unless it's like, any type of device or somebody who's just eavesdropping at the door, I don't see any way that somebody's going to go to jail. And we got to remember, Miss Bumpass, Bump, she was the reason, she was the one that got him to testify. Because his main lawyer went out of town, so the substitute lawyer stepped in, and she the one that got him to testify. So she essentially helped the state. So I don't see Fannie Willis turning around, because that's Fannie Willis district. Fannie Willis turning around and prosecuting, the substitute attorney. So I doubt that's gonna happen. Yeah, because the girl, she helped them out a lot by getting him to talk. So I hope that answered that. Let me see. Either she stinks, or he didn't want to give her his insurance. Watch when the judge calls. That was hilarious. After the judge. Wait, did the judge call just now? Did I miss it? Hold on.
Did I do? They was taking.
Okay.
Did I miss it, or was it earlier?
Oh, okay. I'm sorry. Can you take a break?
Nah, I said, excuse me.
Oh, okay.
Looking at these pictures. Echo Lima. Were these pictures taken in and around the same time? So that's gonna be my first question.
When I took all these pictures? Around the same time?
Around the same year, 2014,
Yeah.
2015.
They should have been.
Okay. So we're saying that these are taken around 2014, 2015. Is that what you're saying?
I'm not being specific when they was taken. I know they, these pictures right here, the ones that I do recall, was taken around the same time.
All right. And what year was that roughly?
I don't know. I can't say what specific. I don't keep up with the days, the months, and all that. I go day by day.
Okay. Let me ask you this. So in 164 Echo Hotel, this picture was taken October 12, 2014.
I don't know what that means. Like 21.
October 12, 2014.
Yes.
Like
well,
number
all these
21.
pictures.
Oh, like number
taken in and
21. Thank
around
you. Thank
The
you.
year 2014, maybe even 2015.
Objection asked and answered.
Oh, we would objection has to answer the question. Yeah.
Yeah, thank you for liking the video. That helps with the the how they show these videos. So I definitely appreciate that.
Wait, can I answer that?
Yes, you can.
Can you ask me again?
Sure. Would these pictures be taken around that time period? 2014, let's start there.
Yeah, like I haven't taken no, like this only time, like I don't know.
Is it fair to say that
Lead.
Almost sustain as to form.
Yeah. Like, yeah, when you're on direct examination, you can't lead the witness. You got to ask questions like who, what, when, where, why, how. But if you say, is it fair to say, is it safe to assume, that's leading questions, and you can only do that on cross-examination when it's not your witness that you call.
Just rephrase.
did you spend most of your time with Young Thug in 2014?
I got to be around him.
Objection for that question.
I sustain the objection.
Yeah, so you can't ask leading questions. We can agree that. See, normally when the cross-examination, you're not really asking questions when you cross-examine a witness. You're really testifying, but you're doing it in the form of a question. And then you tell me you was at the store on this night. And we can agree that when you was at the store on this night, you were the one that actually jumped in the car and stole the car, not my client, correct? And is it fair to say that you were in the car by yourself, not my client, when you drove down the street and stole the car? So you don't want them to start talking and giving open-ended, questions, answers. You want to lock them in a box to like really yes or no questions. when you're on cross-examination. I must have missed the call.
In these pictures of Mr. Williams had blonde hair.
Thank you, Arthur. I definitely appreciate that.
The same group of pictures that we were just discussing. 164 Echo Hotel, 160.
All right.
Does he have blonde hair in his picture?
Miss Mellon, can Brian still use this as an effort in favor of his client? Oh yeah, all of this can be used as an effort in favor of his client.
Is blonde and gold the same?
Do you think blonde and gold are the same?
I wouldn't just ask you that if I thought it.
Does he have yellowish color hair and all these?
Yeah, yeah.
Ms. Hilton, before you pause it, next question. I have it on good authority that we need to take a break.
I have it on good authority too. Y'all better take a break before he jump off that chair. And y'all saw what happened to that judge in Vegas. Judge, so either you or Miss Hilton are gonna be in the crosshairs. Miss Weaver might be all right. Yeah, he's talking about he got it on good authority. Yeah, I do too.
Question. I have it on good authority that we need to take a break. Okay? All right. Ladies and gentlemen of the jury, how about we take a 10-minute break or thereabouts, all right? For comfort. All right, all rise.
Oh, wait. He said something. What did he say?
That's all right, for comfort. All right, all rise.
The judge looked defeated. Defeated. And somebody said that, well, I don't know, maybe when this day, that he said he was going to plead the fifth again, but I don't think that was this day.
We just our conversations about the length of and duration of Mr. I'm just going to recess and as soon as you do 9:30 for a 10 o'clock. Go ahead and call Mr. Copeland back in, please.
Hey, if you watch him, it don't even seem like he want to come back tomorrow, because the judge was like, "Hey, you're going to be here tomorrow," and the judge wanted verbal confirmation, and he wouldn't. It took him a while before he finally said yes, he'll be back tomorrow. He might run the race.
All right, Sergeant, summon our jurors, please.
I think the judge's gonna tell him when you come in and the jurors come in, you have to stand up. Or maybe not. Maybe that was a different part. Maybe not. Oh, he coughing again. What tripped me out with him, they was asking him, "Hey, do you know who Shannon Stillwell is?" He said he can't see that good. He started looking for Shannon Stillwell in the jury box. Now you know damn well he ain't sitting over there with them people. The judge is actually working on his own personal endeavor, dealing with the secret meeting. Just took the break for himself. You need to go ahead and call it,
Thank you, Sergeant Ingram. Point for us today. Tomorrow being Wednesday, and then we'll see where the day leads us, okay?
So he's telling them not to talk about the case. They're going to go home and talk about it, of course. They're going to talk to their husbands, their wives, their kids. They're going to try to figure out why Brian still went to jail.
All right. Mr. Copeland, we'll see you tomorrow morning at 9:30, okay?
No response.
I can go?
For today. Yeah, for today. We're done for the day.
Right now?
Yeah. We'll see you in the morning at 9:30, all right? Yes?
All right.
Okay, all right.
See, he was reluctant. He didn't want to, yeah. Brian said Woody admitted in chambers that he unlocked down Thomas. Can Brian use these? And that's the thing. That's the thing right there. Brian still don't know that for a fact because it's hearsay at this point, but that's why he wants the transcripts. And he's telling the judge, like, hey, judge, I know you're saying that we weren't privy to that information, but actually we were. And when it's our turn to question this witness, once the state gets through with him after 2 weeks, we want to be able to ask him about this, this supposedly confession he made. So, of course, we need to know what was said in the back room. And the judge is like, oh, no, nothing was said, don't worry about it. No, judge, we need to know. And I wouldn't be shocked even if the judge doesn't turn over the transcript as an attorney, I'm going to ask, isn't it true you made a confession to killing Donovan Thomas on your own when you was in the judge's chambers? And just see what he say. And so, in fact, my clients had nothing to do with that, and you acted independently of them and YSL. And if he says yes to that, I mean, shit, that's pretty much a good slam dunk for the defense, because that's cruising towards a not guilty. Now, I'm not saying that YSL should get away with stuff they doing if they terrorizing the city, but you got to have proof that they were doing it as a group. If they doing crimes on their own, then there's nothing wrong with prosecuting them for that one single crime. If this person killed somebody, okay, that person be prosecuted for murder. If this person stole somebody's car, that person can be prosecuted for stealing somebody's car. But what you can't do is just get a whole bunch of random crimes and group them together just so you can get a RICO indictment, so you can get on TV and try to become famous, Fannie Willis, and then try to send these people to prison. Just because one person, Donovan Woody, Kenneth Copeland, might have murdered somebody, that don't mean somebody that stole a car should get the same, 20, 30, 40 years in prison when he had nothing to do with, said murder. So I think she should prosecute those crimes separately if she's gonna do it right. But she want high profile cases. She want to be on TV, and the way it's looking, it don't look like this case is going in her favor. So you did all of that, and they might end up all walking, and particularly because nobody liked Miss Love. Nobody liked that goddamn Adrian Love. I vote not guilty just because of that. I'm still going to watch the live from the beginning. I just found your channel. Oh, thank you. I definitely appreciate it. I didn't know people be up this time of night. Normally, I just like recording it and upload. Well, not uploading it, but doing it as a live because it's easier. You don't have to upload it, and once you're done, because uploading takes forever. So I'll just do it as a live, and I expect everybody to be asleep and just watch it the next day. But y'all coming on participating is, hey, that's good. What time zones are everybody's in? I'm in Texas, so we Central Standard. All of the state witnesses have been prosecuted for crime, right? And it's almost like a kind of like double jeopardy because they get prosecuted again. Because even though the defendants were prosecuted, they get prosecuted again in the RICO, and then the witnesses, the state's witnesses, are getting threatened with having their plea deals withdrawn. See, they on probation for 15, 20 years because they pled guilty. And now they probably wonder, damn, why did I plead guilty? Because I'm gonna be on probation for 20 years and Young Thug and the other the co-defendants might walk completely. So the people that took the deal are probably going to be sick if Watson end up winning. But yeah, I don't think they should be prosecuted twice. That's double jeopardy. Let me see. Who is the mole? I think everyone that is me is going to say it wasn't me. So what happens next? Everyone say it wasn't me. That's a good question. I mean, nobody. From what I gathered earlier, it sounded like Miss Love asked Miss Bumpass, "Did you say anything to the defense?" And it sounds like she told Miss Love, the substitute attorney told Miss Love, "Yeah, they came to me and they asked me, was anything said back there? And the only thing I told them was it wasn't nothing substantive. It wasn't nothing important. That's the only thing I said." So that's what I'm thinking. She's gonna say on the stand. I mean, if everybody hold together, as with most crimes with people that do it in groups, if nobody talk, y'all all walk. You don't talk, you walk. So if Brian doesn't say who told him, and Miss Bumpers doesn't confess to being the mole, then it's gonna be hard for the judge to prove. Oh, you in Georgia? Shout out to Georgia. I'm watching it. Phoenix, Arizona. Wow. They are saying Bumpers, the lawyer who stood in for Woody's lawyer on Monday. Now, Judge, correct. Las Vegas. Yeah. So I guess we're gonna see tomorrow if Woody, what he's gonna do. I'm sure he's gonna show up, because if he don't show up, they're just gonna arrest him again and put him in jail. And right now, he probably don't want to be in the jail. Even the judge may say, "Hey, keep them separate," but you never know. Especially in Fulton County Jail, because apparently that jail is inherently not safe. They say that jail there is broke down to the ground. The inmates can let themselves in and out as they please. They go in their own, say, "All right, good night, y'all," and close their own. So Woody like, "Hell no, I don't want to be in that jail. Did you see the judge was saying, 'I know the lady who told you'? Did you see today the judge told her she couldn't speak about the ex parte meeting? The judge said he was cool in hearing anything." Yeah. But the judge, he go back and forth. He like he don't stick to what he say. Like they say, he double minded man, unstable in all his ways. Thank you for answering my second question. I've been wanting the trial since day one. Yeah, I'm gonna try to do more on it, and because I see more people are interested in it. I mean, it's a circus. Oh, come on, Ohio 216. Shout out to Ohio. Then they told us say they couldn't hear the sidebar. It doesn't concern. The state, they told the state that. I'm shocked. Oh, okay. Here's one. But yeah. Well, I definitely appreciate y'all stopping in. And since there's so much interest in this trial, I think I'm gonna just keep on covering it. I know some other people are covering it, and everybody got their own styles. Right, he's doubling down when he should have. He should have came out and took a deep breath, thought about it, and said he withdraw his order of contempt. But he held bent on being right. How about Karen Reed? Will you cover that? Which one? Let me see. Which one is Karen? I've seen so many. Oh, damn, man, that just got. I'm so far behind on that one. I believe AB's covering that one, but I think I have like a gist of the story. Supposedly, she killed. I don't know if it was a boyfriend or her husband, but they saying that it wasn't her that did it. It was maybe some other police officers that was in the house that night, and her vehicle didn't have enough damage to have run him over or backed into him. But a lot of people are saying they don't like the evidence that the state is using against her. He acts like they are his kids who get in trouble and he tries to teach them lessons. Right. There was a duty to inform them. Oh, yeah, for sure. Big time. A big duty. Even at the very least, you're supposed to tell the defense that, just so you would know, we had an ex parte meeting this morning and who all was present. And if you want to make a record of an objection to our meeting that we had, then I just want to inform you that we did have a meeting. You can put your objection on the record. But the judge not only didn't tell them what happened in the meeting, he didn't tell them about the meeting at all, which is suspect in of itself. And then he want people to trust him, like, oh, I have nothing to hide. We didn't talk about nothing. We didn't talk. Well, apparently, y'all talked about a lot because apparently the guy admitted to murder. He was pressured into testifying, even though he wanted to assert his Fifth Amendment right. Y'all threatened to hold him in jail indefinitely, up to 2 years or longer, until all the trials are over with. Because we got to remember, this is not the only YSL trial. It was another attorney that was arrested at the beginning, and his client's case got separated from these defendants, so he ought to have a separate trial. So what they were telling him was, not only will we hold you until this trial is over, we're going to hold you until all the other people's trials are over with, the ones that got separated. So they were really intimidating him, intimidating a witness. So of course that's, when you intimidate a witness, then they're going to come out and say whatever you want them to say, so you don't do what you threatened to do to them. So yeah, we need to know that as defense attorneys. Melnep sent an email. Yeah, apparently he sent an email saying F you to Ms. Love, and he CC'd Brian Steele in that email. Oh yeah, and Ms. Love, don't leave her out. I know your last stuff, Love. Hey. Love ego ain't gonna let this case go neither. That's the hill she gonna die on before she let this case go. I know that's right. Especially in Fulton County. I think they did something on the news and they had a thing of all the weapons and stuff they found in there a while back. So it's definitely a place that nobody want to be in. They had to hurry up and get Trump out of there. They tried when he got booked in. They had to hurry up and get him out of there. Did y'all see Biden's son got convicted? Man, we gotta look at it. If Biden's son get probation, then okay, no big deal. But if he go to prison, if I was a son, I'll be telling my dad, hey, I need you to pardon me. Because you gotta look at it. If Biden win, he can't be reelected for a third term. So I mean, it's not like he's gonna be voted out of office if he wins and pardon his son. And if he lose, I mean, he's not gonna be never president again, obviously, because his age, he's at the end of the rope. So before he leaves office, he can still pardon his son. Which is, to be fair, that is a strange crime. If you have a drug problem, you can't buy a gun. But the issue is most people that have drug problems don't think they have drug problems. So, that's what that came down to. which is wild. You know, we got so much going on with guns and you know, schools, but if you have a drug problem, you can't get a gun. When she heard Steele was going to go to jail, she had a moment and thought that could be her. Who? Which one? Wait, which one had a moment and thought that was her? Who I missed? Did I miss? Let me see. Oh, she'll take that judge downtown for a minute or two before she go to jail. Judge, let me holler at you in the back. We need to have another ex parte meeting. We need to have one of those secret meetings. He gonna come back and change his mind, reverse. He gonna say, love ain't going to jail. It was a song by a man called Marvin Seas. He said she get it all. I gotta check that out. She get it all. He gonna give love all of it. They say that's his woman. Don't give me the line now. Don't give. And these secret meetings confirmed it. Wait, a smaller version? Oh, you talking about what? Oh, okay. If I'm saying because love, she look like she tall. Like she tower over you know, like everybody in that courtroom. Oh yeah, yeah. That woman there, and she would not take you know, no for an answer. She would not accept losing. Yeah, that's what I figured. Yes, yeah, skinny. Yeah, I got you. She would not accept losing. Not auntie love. All the lies she holding a whole lot of lies instead of her nose growing like Pinocchio. It's her legs. Y'all are funny. That's why Glanville treats her like that. Man, I'm telling you. And you know, when the trial first started, it probably seemed far-fetched. Like, hey, you know, y'all thinking too much into it. They don't got nothing going on. But then come to find out, they meet in the dark with witnesses. So now, once they did that, you can't put nothing past them. Nothing. And instead of the judge owning up to it, like, hey, I should have said something that slipped my mind. I didn't realize that it would cause an issue that the defense needed to be present. Let's bring out the transcript. He doubled down saying, who told you? You bastard, why? It matter who told me. Why the hell you do it? God damn it. So I don't blame Steele one bit. I mean, as an attorney, as a zealous advocate, wait. you gotta advocate for your client as if it were yourself. I mean, you literally are speaking for them. So if something happens, let's say your lawyer mess up and your lawyer doesn't object or your lawyer doesn't move for a mistrial, guess who the appeals court going to blame? They're not going to blame the lawyer. They're going to say the defendant, Michael Woods, complains of such and such, but he failed to object during trial, so he waives that issue. The defendant waives that issue. Even though your lawyer didn't object, since your lawyer is speaking for you, they're gonna take it out on the defendant. So the lawyers are literally speaking for people. So you gotta fight as if it's your own life at stake. Not hit me all the way upstairs. I thought you was gone for the night/morning. I mean, I can hear you all the way upstairs. I'm up there working. Kind of work that I got going on this time of night. I just quoted that real shit. I'm like, my man still on. That's I ain't still on. That's another video. No, I was looking at the clock, so I was like, okay, maybe I can get 4 hours. I'm almost there. I said I get 4 hours, and then that'll be a record. Come on. That motion that Glanville signed had the one's name was who supposedly gave Thug the drugs in court versus the lawyers about the contempt. Wait, let me read that slow. The motion that Glanville signed had the one's name who supposedly gave Thug the drugs in court versus the lawyers about the contempt. Let me see. KAHLI. It does show his name at the top. Is he one of the defendants in the case? Yeah, I see Khalif Adams' name on there, but I'm wondering, is he one of the defendants in the present case? Yeah, see at the top it say Khalif Adams. State of Georgia versus Khalif Adams, which is strange at all. So I guess Khalif Adams and the rest of them. But I wonder if his trial is he part of the co-defendants? Let me see. Let me see who the. Yeah, I don't even think he's on trial with them right now. Let me see who is on trial. Yeah, that's real strange. Who was on trial with Young Thug? Huey, Kendrick, Nichols, Ryan, and Stillwell. And obviously Jeffrey Williams, because he's the main one. The other defendants have already pleaded guilty to various charges, including Gunner, Sergio Kitchens, Thug's brother, Trontavious Stevens. Let me go back. Oh, that was it. So I don't know why they got the other guy's name. That is strange. I'm gonna have to look into that. But I believe that Adams already serving life for a murder. I was a little delayed. Let me see. Oh, what I mean? Okay. Emotion. Okay, that's the one. Okay. A little delayed. I'm getting the video today. Oh, okay. I'm gonna go check it out. Export to the hearing. that he filed today. I seen that too, Tamika, at the top of the order. The judge is worried about who rather than what happened. To me, what Steele stated that was said during the right. The judge is more worried about who the mole is versus the constitutional rights of all the people in the courtroom. Whether the mole is found out or not, that's a separate issue that's irrelevant to whether the defendants spend a majority of their lives in prison. So it seems like the defendant's rights will trump the judge wanted to know versus these people's lives are at risk and on the line. But he's so caught up in, I gotta know. He asked so many times, it's ridiculous. I'm sure before Friday get here, we still gotta go report to jail. He's probably gonna give him one last chance. Just tell me, you don't have to go. Just tell me. They said he threatened Woody. Oh, so once he get at the thug, they separated him. So maybe he got a case still coming up. So maybe he's one of the trials that's separated from the rest, which is what the prosecutors was telling Woody, like, hey, Woody, even after this trial is over, we can still hold you in jail because we got more trials after this. So yeah, that ain't right for them to be beating up on that boy like that. And his lawyer, his substitute lawyer, is in there letting it go on. Yeah, I think Adams got life for a murder, but I don't think he actually got life for I don't think he ever had his day in court yet for the RICO itself. Let me see. I'll double check that though. Let me see. Khalif Adams. Boy, he already got life, and they still don't want to. They still trying to bring him in. See if I can make that bigger. Okay. Oh, so I didn't even know somebody mama got arrested for trying to pass tobacco. Golly. Oh my God. Now on Thursday, Khalif Adams was charged with possession of a Schedule II controlled substance. Okay. Defendant Adams, who is currently serving life without parole. Right. So yeah. Plus an additional 55 years. Okay. So of course he's gonna be the one to pass the drugs. He got nothing to lose. He got life without parole plus an additional 55 years. And they're trying to charge him with this RICO. I guess the only reason they charging him with RICO because they want to bring him in to tie him in with everybody else. So so whether he win or lose his trial when it comes up is, really of no consequence. But that's wild. Adams got life way before this case. Okay, but why was he in court? And I'm thinking he was in court to tie him in with the other one. Okay, Super Kicks is gonna watch. Oh yeah, Super Kick. Thanks to Mika. 100. So they're protecting Woody from something he was does or does good friend. I think I heard on video. I can't remember. That's what I heard too, which is wild. He killed his own friend just because murder is related to the gang, allegedly. Right. So I'm guessing they're trying to tie that murder in as well as being part of the RICO. So I guess they're gonna say, hey, not only did Kenneth Copeland kill Donovan Thomas on behalf of YSL, you got this Khalif Adams that's currently serving life. He was convicted of it for killing this other dude on behalf of YSL. So they're bringing in all these people to try to tie everybody in together, which is wild because, like I said earlier, if y'all want to go after them, just do it like y'all did Khalif Adams. Y'all charged him for murder separately. He was found guilty and he was sentenced. But I'm thinking what she really wants, she wants Young Thug. She already went after, what was it? The YFN group. Lucci, and now she want, she want another head honcho. Yeah. So we gonna see tomorrow what tomorrow brings. I definitely appreciate y'all hanging in there. I'm gonna check out some of these reviews before I right. Some of them they don't have nothing to charge them with separately. I know they said Young Thug rented a car, but other people were driving the car, the car dealership, the car rental person didn't remember ever seeing Young Thug. He can't recall who picked up the car, who dropped it off. So I mean, it's a whole bunch of nothing. If you ask me, they have nothing to charge them. So, okay, and if Woody admitted to a murder in Judge's chamber, that's crazy. Yeah, that is crazy. But at the same time, his lawyer probably told him like, "Hey, you can admit to it because you're still protected by immunity." So anything you say, because the court reporter is still back there typing, anything you say is protected by immunity during this whole trial. So we can't use nothing against you ever based on what you said. But they can go and use outside evidence against him because now that they know he did it, because obviously he told them he did it, now they can go and put their own pieces together to figure out how can they nail him without using his actual words in court, because they can't use his words that he said in court, obviously, because of immunity. So I hope he didn't open up a can of worms for himself, procedurally, because his lawyer set him up. But then again, I'm sure Donovan Thomas' family probably want justice now. So we'll see how that go. Don't you find it odd that they didn't want him to have a lawyer? Yeah, and that's probably why the other lawyer told Ms. Love F you in the email. He said F you. Man, we haven't found Rico, Marco, Polo. We still looking for them. Where they at though? What if the feds pick him up? He's not protected then, right? That's a whole separate jurisdiction. Can the state immunity, which covers the state of Georgia, can that shield you from federal prosecution? And that might be an issue in and of itself, because he's a convicted felon, and I believe he still have a pending drug case, out. Now that could be something that can go to court. Hey, I got immunity and I was forced to testify, and now the feds are coming to pick me up. Now, would the court say, hey, the state and the federal government are separate entities, which they have ruled in the past, that the state and the federal government are separate. That's why the president cannot pardon state crimes, and the governors of these states cannot pardon federal crimes. Only the president can. So we're gonna see if time gonna tell the story, as they say. Well, all right then. Thank y'all for hanging in there with me. Let's see what it looks like. I'm gonna jump on tomorrow. Hopefully, I'm gonna try to do it in the daytime and something later on in the day. But before I go, let me give the disclaimer. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right, I'll see y'all hopefully tomorrow. Thank y'all for stopping in.